Today we're going to talk about and introduce a concept called repudiation. And we couldn't have picked a better time to talk about this topic because repudiation, actually, we're going to first learn the concept of repudiation in a relatively simple way. When a person says they won't perform their obligations under a contract, but then on Monday we'll move into a topic called anticipatory repudiation, where you feel like your counterparty will be unable to perform and you have the right to demand assurances. And that's happening all around the world today. All around the world, promises are being broken. I mean, Amazon didn't get my stuff here to me within 2 days. I mean, come on, first world problems, right? But like major disruptions in commerce happening today. And so the doctrine of repudiation, anticipatory repudiation, and what you'll see in the Minwell case from today is a story I think we can translate to our own times. And I'm working in the background. I don't know if I can get it together by Monday. I'm going to try, but to try to really bring in some examples from things that are happening in the real world right now and apply our contract knowledge to show you just how valuable what you're learning is and to what extent it really matters. Because basically we're facing an economic crisis where a lot of deals are being broken. And how is the law going to deal with that in such a broad way? So let's go through the basics, and then we can get into some more kind of advanced topics. All right. Repudiation is actually a pretty simple concept. Repudiation simply means that a party refuses to perform, says that I won't perform. And the question is really of timing. When do they say such a thing? They would say such a thing before the time for performance is due. In other words, remember our case from all the way back from Monday, right? We're keeping track. Now I'm keeping track of the days. This is so weird. Now, yesterday, virtual yesterday. Last time we had class, we talked about Sackett v. Spindler, and there's a payment due on August 15th. And he made a bad check, wrote a bad check, bounced the payment on August 10th. Now, as of August 10th, payment was not yet due. And I told you we'd get back to this concept. So what might have happened? Well, by writing a bad check, that might have been a repudiation of sorts. We could actually analyze that here because before performance was due, the promisor did something which could have been interpreted as disavowing the promise. Now, I don't think it would have passed that analysis, but well, let's see. And by the way, just a synonym for repudiation is renunciation. So this is when a person refuses to perform before performance is due, and it has to be, this is why that probably didn't happen in Sackett, it has to be unequivocal. And what is the effect? If a person makes an unequivocal repudiation, it gives the injured party an immediate right to total breach. And when we parse through the language in the restatement around this, we'll see that total breach and repudiation are closely related conceptually. And what does a total breach do? A total breach discharges the injured party's remaining duties. We know that already. It's the same effect as the total breach that we have already explored. Now, a couple rules. The repudiation must be unequivocal. It has to be absolute, not a mere expression of doubt. And this is the main point on which the McCloskey versus Minwell case will turn. And we'll turn to that case in a minute. So statements or actions can constitute a repudiation. A statement would be like, I'm not going to mow your lawn. Or how about your, I'm sure I've come up with real world examples here. How about your babysitter is supposed to come on Saturday and take care of your kids. And on Thursday, she calls you and says, I have coronavirus. I'm not going to come on Saturday. Well, that's a repudiation. It's pretty unequivocal that you shouldn't stand around and wait for her. And moreover, why is it important as a matter of law to declare this a repudiation? Because you need someone to take care of the kid on Saturday. And by declaring this a total breach, that gives you, the injured party, the right to terminate the contract and mitigate damages by hiring somebody else. But it has to be unequivocal. Now, we get into trickier situations where the housekeeper says, the babysitter says, I've developed a bit of a cough. All right, so let's just put that out there. So, you're supposed to have a babysitter come on Saturday. We're living in a world where coronavirus is happening. People who get this disease are supposed to self-quarantine. And the statement that you hear from your babysitter is, I've developed a bit of a cough. Now, do you have the right to cancel the contract and hire another babysitter, or do you have to allow her a period of time to perform? So we'll take a vote. Who thinks that if the babysitter says, I developed a bit of a cough and it's Thursday, you have the right to terminate the contract? Vote yes, and vote no if you feel that no, that we need to let this play out for a little longer time. Yeah, it's a close call, right? It's a close call. Why is it a close call? Because it's not equivocal what she's saying. First off, there are a lot of things that can cause a cough. It's not necessarily COVID-19. Is it possible she still perform? Yeah, I mean, what are some other states that could play out here? Well, what if she got tested on Friday and found out that she wasn't infected? She could still come. It's not impossible. She didn't, but you have reason to be concerned. So I could ask that. I mean, we'll just put this one up there. I think, well, I don't even need the yes, no. I think the answer is yes. In the world we live in today, if your babysitter calls you on Thursday and says, I'm feeling really sick, should you feel slightly concerned that she won't be able to take care of your kid on Saturday? Yeah. So we'll get to that next when we talk about the right to demand reasonable assurances. But that's going to be our topic for Monday. So repudiation is more than that. So basically you can think of it as repudiation is a very high level, has to be an unequivocal statement or action such that the party cannot and will not perform. But something less than that, something more minor, like a statement like, I'm not feeling well and we're in this circumstance, that might not give you the right to cancel, but it might give you the right to demand adequate assurances, which is going to be our subject for Monday. And so as you see on the screen, a mere expression of doubt is not enough to constitute a repudiation. As I mentioned, repudiation can come in the form of both statements and acts. And how could we repudiate by action? So what are some actions you might think of that make it impossible to perform? Well, let me go back to my favorite example of trying to sell you my car. And we agree that on Friday, I will sell and you will buy my car for $10,000, right? Today's Wednesday. So what if I sell the car to somebody else on Thursday? Can I still perform my obligations to you? No. No, I can't perform. I don't have the car to sell anymore. So this is an example of a implied repudiation through action. The repudiation by my action, by selling the car to somebody else, I made it impossible to sell it to you, and therefore I repudiate. I didn't say anything to you, but some of these things are like recorded. So think about something bigger, like a house. When a house gets sold, I'm channeling Professor Gebru here, but when a house gets sold, there are filings that you make. You records and deeds and the whole race notice thing, and if you are under contract to buy a house from somebody and you find a record or you get an alert from Zillow that that house was sold to somebody else, well, then you can be pretty confident that they repudiated by action as well. So let's talk about the letter of the law for a minute and just get that right. So according to the restatement section 250, a repudiation is a statement by the obligor to the obligee indicating that the obligor will commit a breach that would of itself give the obligee a claim for damages for total breach under 243. In other words, a repudiation has the same effect as a total breach. And as we'll see in Hester versus De La Tour, this also means that the other person does not have to wait any longer, because once a total breach occurs, the harmed party can terminate the contract and find someone else to do the work. So as soon as the repudiation is made, that constitutes a total breach and allows the other person to find someone else to do the work. So the consequences of a repudiation are the same as the consequences for total breach. But again, we only are going to find this total breach if the repudiation is unequivocal. Let me give you an example. We're kind of testing here equivocation. On April 1st, A contracts to buy and B contracts to sell land, delivery of the deed and payment of the price to be on July 30th. On May 1, A tells B that he will not perform. It's repudiation, right? I will not perform. That's clear, that's unequivocal. It's not an expression of doubt. There's no sense of maybe if this, maybe if that. All right, so we're going to start off, clear, unequivocal statement. And so what rights does B have? B now has the right to terminate the contract. All right, another similar example. A contracts to build a house for B for $50,000. Progress payments to be made monthly in amount equal to 85% of the price of the work performed during each preceding month. The balance to be paid on the architect's certificate of satisfactory completion. Without justification, B fails to make a progress payment and tells A that because of financial difficulties, he will be unable to pay him anything for at least another month. So can we see that this is a little bit more of an equivocal situation, right? What is the situation that we're in here? This person is in financial trouble, but financial troubles can be resolved. There's not a clear statement of never performing. So we have to give a little time. So the restatement says that if after a month, it would be too late to cure. That's a big if, right? Maybe that's too late to receive the payments. Then the statement would be a repudiation. But we know that there's a little bit of time to cure. And so we have this brief cure period, even though it sounds unlikely this person is going to succeed in making the payment. This is the situation which gives rise to anticipatory repudiation, or the right to demand assurances. That's what this if is about. It's a factual question. So we'll return to that in our next section. All right, how about something that's not a repudiation, right? So we saw an obvious repudiation, something in the middle, and now let's go to the other extreme. On April 1, A contracts to sell and B to buy land, delivery of the deed, and payment to be on July 30th. And on May 1st, A tells B, I am not sure whether I can perform, and I do not intend to unless I am legally bound to do so. Now, what's different about illustration 1 and illustration 3? Illustration 3, the guy says, I'll perform if I have to, and if I can. So there's some amount of doubt, but this amount of doubt is not, it's equivocal, right? This doesn't rise to the level of refusal to perform, and so this is not a repudiation at this point. All right, another hopefully somewhat simple example, saying with our same kind of situation. On April 1st, A contracts to sell and B to buy land, delivery of the deed and payment of the price to be on July 30th. On May 1st, A tells C, a third party, he will not perform. C informs B of this conversation, and the restatement here says this is not a repudiation. So that's interesting. Why would this statement not be a repudiation? Let's go back to look at the rule. A repudiation is a statement by the obligor to the obligee. A repudiation is a statement by the obligor to the obligee. What's happening in illustration 4? In illustration 4, we have a statement by the obligor to a third party, and then a statement from the third party to the obligee. As a result, this does not qualify as a repudiation, not insofar as its statement. I think what we're looking to avoid here is sort of like hearsay, although you haven't taken evidence yet. But the idea that we can't always trust what somebody says somebody else said. But really, it's just if you had elementized the rule and you had noticed this particular element by the obligor to the obligee, then it must follow that illustration 4, where we have a statement to a third party and the third party to another, that there would not be repudiation. Okay, this is a great question. What if the third party is a worker or someone under the power of B? Now we have a different doctrine. We have an agency concept, a couple different agency law concepts, and it's not necessarily respondeat superior, which is a tort concept. I'm blanking on the name of the particular agency doctrine, but imputed knowledge. The concept is called imputed knowledge. The knowledge of an agent is imputed to the principal. So in that particular case, if the third party was an employee of a corporation, there's a different test, but we might actually find that the corporation had imputed knowledge because of the statement to the employee. And I could look that up if you're interested later, or we could pull up the restatement section of agency and look at the test for imputed knowledge. So that would be a little bit different if there's a relationship between, an agency relationship between C and B. All right, second part is describing when an act is a repudiation. So a repudiation is a voluntary, affirmative act, which renders the obligor unable or apparently unable to perform without such a breach. All right, so again, we're talking now about the nature of the act or the nature of the statement. And so now if we're looking at actions and not just words, the action has to be, once again, obvious in that it prohibits someone from doing the work. So the other thing that's notable here is that we have this concept of it being voluntary. An act that falls short of a voluntary act, as we'll see later, may give grounds for reasonable assurances. But again, the repudiation standard is like up here. Repudiation is like a really high bar to achieve, to find that it has occurred. And so a repudiation requires a voluntary act, such as deciding to sell my car, not to A, but to C. That's a voluntary affirmative act, which I did. Now, getting a virus or getting or becoming insolvent because my 401k portfolio is zero now or something like that, those aren't voluntary acts, but they still might make it hard for me to perform, but we just would do a different analysis. If the act is involuntary, like getting sick from a disease or like war breaking out or like, the stock market turning down, we would look to the next doctrine of when we can ask for reasonable assurances. And so let's take a look at one of those acts. On April 1st, A contracts to sell and B to buy land, delivery of the deed and payment of the price to B on July 30th. On May 1st, A sells the land to C. A's act is a repudiation. Why? Because this was an affirmative, voluntary act. Now, again, let's turn the facts a little bit. If instead of selling the land to C, maybe on what if on May 1st, A received a notice that the land was not recorded properly and someone else had a claim to that land. We're going to see something similar with a concept with I'm so bad with all the property terms. They're all funky, but like it's a dowerly, the guy's wife has the reversion. And so there can be issues that come up, and we'll see that, and those will come up in the next topic for Monday. All right, so I'll conclude and then pause for some questions. A couple overall thoughts. Repudiation is a statement or act which indicates that the obligor will breach. An unequivocal statement. The statement must be sufficiently positive to be reasonably interpreted that the party won't perform. Merely sowing seeds of doubt as to performance is not enough for repudiation, but it gives the doubting party right to further assurances. So even if it doesn't get to the level of repudiation, we can get to the level of further assurances. And an act must be voluntary and affirmative and makes it impossible to perform. And again, an act that falls short of these requirements may still qualify as a right to demand adequate assurances. The breach threatened by the repudiation is going to need to be a level of breach that would constitute total breach. And repudiation by one party has the effect of total breach. It discharges the party's duty and gives a rise to claim for promises for breach.